Lads and lassies, we're back over here with Judge Shackelford, and she mad, even more so than usual. She is not happy with this little down that way. This little lad down here in the corner here. This gets really, really heated, really, really fast. And after that, we have a bonus young Karen. Looks like a lot of fun. So let's check this out.
Your Honor, these allegations are false. The victim has came forward and said that she lied. Your Honor,
all right, I'll
she
see
is
Mr.
my
Fitz
fiance.
Here by 3 o'clock today.
She is my
Who's that
fiance,
with you, Mr.
Your
Fitz?
Honor.
Who's that with you, Mr. Fitz?
This is
who's over to the side of your camera. Who's
Jasmine, my wife, my soon-to-be wife, Your Honor. That's why I needed to talk.
I said what I said. You're to be in this court in person for your arraignment by 3:30 this afternoon. And your attorney can appear via Zoom. Call your lawyer. I'll see you by 3:30.
Good morning to you and your staff. Jonathan Jones, 52920, appearing on behalf of with Mr. Phipps. Thank you for letting us do this remotely. Obviously, we consent. To the arraignment, Your Honor, I'm going to acknowledge receipt of the general, waive his formal reading, and send a mute.
All right, I'm a little concerned about these allegations and the fact that Mr. Phipps doesn't, I mean, he's not in custody, but he's going to have some significant bond conditions.
Excuse me?
Michael, be quiet, please. Judge, if I may, I understand where you're coming from, but I want you to know as an officer of the court that the complainant has reached out to me independently. I'm going to leave it at that. He has not had any contact with her. He will not have any contact with her. I want the record to reflect that the court scheduled this. We're grateful. We're here. He's absolutely not a flight risk, and the condition.
So just remember what he said. Like he said that he will absolutely not have contact with this lady. Let's see if that's true.
He will not have any contact with her. I want the record to reflect that the court scheduled this. We're grateful. We're here. He's absolutely not a flight risk, and the conditions of no contact have been respected and will remain in that manner.
Jonathan.
Yeah.
Michael,
No,
please
I mean,
do not speak.
Mr. Phipps, it's my, listen, you have an attorney. If you want to say something to the court, you're free to do so, but you have a right to remain silent. You have a right to have counsel. So is there something you need to say?
Yes, there is something. Yes,
okay,
there is something that I need to say.
Good, tell me.
Well, I would like to talk to my attorney real quick because evidently he's not aware of anything.
Oh, he's not aware of anything. Oof. All right, you know what? You need to be here in person today. You have until the end of the day.
Your Honor.
Judge, I can't.
Need you in person at the 23rd District Court in person by the end of the day. I can put you two in a breakout room. You're coming in person. I'll see you in a little while.
Judge, I cannot be there in person. I'm scheduled
Your
for
Honor.
1 o'clock, and today is the Jewish holiday. I cannot be there in person.
Why can't
well,
you
your
come?
client can.
Well, that's fine, Your Honor, but I'm not going to be able to be here with him. I'd like to get him arraigned now. He and I can speak.
No, I want him. He is charged with a home invasion first degree.
Your Honor, can I speak,
He is
please?
charged with a home invasion first degree. He is charged with.
Your Honor, can I please speak?
I'm not. Do you hear me talking?
Yes,
he is charged with a 20-year felony. He is charged with assault with intent to do great bodily harm, less than murder or by strangulation. He is charged with domestic violence. He is charged as a 4th habitual offender. He has multiple prior assaultive convictions. I want him here in person. I've said what I said. I said what I said. Make it happen.
Your Honor, can I speak, please?
You have until 3:30 to turn yourself into the court.
Your Honor, can I please speak, please? Please say something, please.
Go ahead.
Your Honor, these allegations are false. The victim has came forward and said that she lied. Your Honor,
all right, I'll
she
see
is
Mr.
my
Fitz
fiance.
Here by 3 o'clock today.
She is my fiance, Your Honor.
Who's that with you, Mr. Phipps?
This is
who's over to the side of your camera? Who's
Jasmine, my wife, my soon-to-be wife, Your Honor. That's why I needed to talk.
I said what I said. You're to be in this court in person for your arraignment by 3:30 this afternoon.
He keeps moving
And your
around.
attorney can appear via Zoom. Call your lawyer. I'll see you by 3:30. Oh, Mr. Verdude, you're here to cause some trouble, I see. This is 250941, the People versus Jessica Glask, Jazerski. All right, go ahead, counsel.
James Gazicki on behalf of Mrs. Jazerski. I just received a file today, and she's gone over her rights. There's no question regarding her rights, but we're requesting a hearing in this matter. I'm asking the court for an adjournment so I can review the file and be brought up to date in this matter.
All right, well, where you should start is you should ask Ms. Wagaman to play you the audio of a call that was submitted to her where Ms. Wagaman contacted the defendant about not having any contact yet again with the complaining witness. And she hung up with him and then immediately called the complaining witness and had a phone call based on her call with Aaron. That might be a good, I'll adjourn it, Mr. Gizicki. I'm just telling you that way you don't have to go into it too much. You could just listen to that call. She has a no contact order. How many times do I have to tell you that? How many times?
I understand you.
No, you don't understand. Because no, and what did I tell you? What did I tell you when he calls you? What did I say? And what'd you do? Instead, talk. You are not supposed to be talking to him by my court order. And this is the second time I've seen you. And the last time I said, this is ridiculous. Don't cry now. Last time I said, this is ridiculous because he's contacting her and these two are going back and forth. And then I counseled you and said, do not respond to him. If you respond to him, I'm going to put you in jail. There's no contact. And you can't listen. I mean, you can't. And Mr. Verduke, don't think you're cute because I'll see you next week on a violation. Am I seeing him this week?
I don't know, man. I think he looks pretty cute. Look at little meth mouth. He looks so cute. Poor little.
No, he'll be here next week.
He'll be here next week. You two are toxic. And this is what's irritating me. You're wasting time on the criminal justice system's time on whatever you two have going on between you. You're wasting the time of the courts. You're using the criminal justice system. Mr. Verduke, I'm looking at you. You're using the criminal justice system to deal with your two little petty problems. That's what you're doing. And I'm tired of it. And what's becoming clear to me is that maybe probation is not suitable for either of you on your cases. And maybe it'd be best if you just do your jail time when we get this over with, because I am not going to play this game. I'm not going to ask Ms. Wagaman to play this game for much longer. This is it. So we'll set it for a hearing. Mr. Verdude, I assume you'll be recording when she calls you after this hearing. Make sure that Ms. Wagaman gets that, because if you call him in between now and your hearing, you have any contact with him whatsoever, I want to be clear. I am revoking your probation and I am locking you up for 90 days. One time. Do you understand me?
I understand.
Are you sure?
I'm sure.
One time. If she gets one thing that is from right now at this moment, at what time is it? 3:57, Monday, September 22nd to next week when we have your hearing, bring your toothbrush and wear a sports bra because you're going to jail. Got it?
Got it.
Well, that got fiery really quickly. So I've got another one for you here. It's a young Karen, and she gets a little bit cheeky with the wrong judge, another really tough lady judge, Judge Raquel West. I haven't seen this one before. Somebody told me about this one. I was like, all right, okay, let's check this out. I've been kind of out of the loop a bit.
Worse, so you probably need to fix your attitude real quick, because having a bad attitude with me does nothing good for you.
I believe. Let's see.
Good morning, you're Gracie Cassidy?
Yes, ma'am.
And Miss Cassidy was previously in court and entered a plea of guilty in cause number 24 DCCR 1480 to the third-degree felony offense of unlawful carrying a weapon in prohibited place. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
State has to.
Yes, Your Honor.
Are there any additions or corrections?
Your Honor, the only, fact I would like to say is she's now living in Georgia and it'll be transferred to Georgia for supervision.
Just make sure when you talk to probation, they'll get that all taken care of. The biggest thing about your probation being transferred is it kind of means you have double duty. So you will be reporting in person where you live, but you're still technically on this probation here in Texas. So it's not like the whole. Well, no, there's one fee, but you will have to report either by mail or online here as well each month. So you're going to go in person there, and you also have to report here. So you can't forget to do that mail-in or the online reporting here, because that would be a violation. It's just a lot of people they think they're doing everything right because they're reporting in person over there, but you have to stay in touch with us as well. All right.
Judge, real quick, I apologize. There is one thing, and I spoke to Mr. Megan about this previously.
Oh, that's right.
There seems to be maybe a new charge in Georgia. I don't know the circumstances of this, nor do I recognize the charge.
Yeah.
And it's equivalent with us.
Hang on, ma'am.
So that's the only thing that's new that I wasn't aware of, and I spoke to Mr. Megan about before, and he was gonna find out.
Okay, so whatever you have to take care of, obviously in Georgia with regard
I
to.
don't have anything to take care of. That was like what they were holding me on in Georgia.
That's the case, Judge, but
But I got in a
I-
car accident, they arrested me because I had a warrant here.
I got you. Okay. All right.
But I believe they dealt with that. Well,
Okay.
there was nothing to deal with, I just like had to find out.
That's where you got arrested and then they transferred you here?
I didn't get transferred, I just had to sit in jail for 44 days
Okay.
to find out.
Okay. Got it.
That's
Okay.
sufficient for the state.
All right.
I just didn't know.
Okay, Ms. Cassidy, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient
I have a question.
Yes.
This packet, it said like I had to do like 300 hours like community
Mm-hmm.
service.
She'll explain all that to you at probation.
Yeah, that's what happens when you're on felony probation. It's required. If you talk to your probation officer, if you're doing everything right, sometimes they waive part of those. Sometimes they don't. It depends on how you're doing. Do you understand? This could be a lot worse, so you probably need to fix your attitude real quick. Because having a bad attitude with me does nothing good for you. Okay. So I'm going to find sufficient evidence to find you guilty, and at this time, I'm going to follow your agreement and defer all proceedings and place you on probation for 4 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty and sent to prison for anywhere between 2 and 10 years. Do you understand? Okay. One thing is on these types of probation, if you do everything you're supposed to, I sign early terminations from probation all the time. But it means you have to get it all taken care of early and up front. So take care of everything, and then there's the possibility of getting off early. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork.
That wasn't
Right?
so bad. I mean, that could have been way worse. I thought she was gonna like throw a tantrum or whatever. I figured I wouldn't watch it until I was recording this so that I'd, be a legit live reaction to it. But that wasn't so bad. I mean, clearly a young lady that's never, been told what to do before. But yeah, that could have been way worse. Anyway, lads and lassies, I hope you enjoyed the video. If you did, make sure and like that. Like that like button. Yeah, why not? I mean, you can like it too, but definitely do hit that like button and leave a comment down below, and we'll catch you in the next one. Sanja.
People of the city of Southfield versus Rhonda Hahn and 25S00229FY. People of the state of Michigan versus Rhonda Hahn.
Jason, this is the people here on the state case.
Good morning, Your Honor. Bonnie Prince on behalf of the city of Southfield. The city case.
Oh, the Judge Jordan's up, keep on the silence forever.
Okay. Miss Hahn, what's your name? Okay, so the city case is the operating with a no massage establishment license. So that's the misdemeanor, 90-day misdemeanor. Alrighty, and then we have the state case being several counts. Let's see what we got here. That was scheduled for a preliminary examination today. On count one, prostitution accepting earnings, a 20-year felony, and human trafficking enterprise causing injury. That was count two, a 15-year felony, $15,000 fine. And then keeping a house of prostitution, 5-year felony, $5,000 fine. All right, so what are we doing on the felony?
Judge, today's the time of examination. As you said, we have no witnesses who have appeared. We are unable to proceed at this time. So I think you're standing the law to be dismissing this case. We just asking without prejudice.
I would ask for with prejudice. We have been here numerous times for exam, no witnesses, but obviously that's the court's discretion.
There's no grounds for that.
I was gonna say, it's not really my discretion. I have to have a legal basis to do it with,
Clearly, there's no cooperation.
if they want to keep trying, they can keep trying.
Take it without.
Okay. All right.
There is a resolution.
Yeah, I figure. So ma'am, on the state case with the 3 felony counts, we're gonna go ahead and dismiss that. It will be a dismissal without prejudice. So what that means is that the prosecution could try to hunt down the witnesses and try to send warrants, material witness warrants to the witnesses. We try to get them to come. And if they do that, they could rewrite the whole case and it could start over. They could choose not to do that. And if they do, then it remains dismissed. You had your hand up for some reason? I can't. There's no basis for it. Where's the prejudice that has attached? We haven't even done anything. And we've taken that one shred of testimony.
And Judge, there was a material witness warrant in this case with one of the witnesses. I asked them to cancel at this point as the case is dismissed.
Oh, yeah, let's see. I would guess, I don't know if you need me to do an order.
I believe so, Judge.
So could you grab one out of the podium, give it to Mr. DeSantis, let him write an order canceling that warrant? Unless you just want to leave it out there, unless they find the person.
I don't think that's appropriate at this point.
Okay.
Thank you.
And we have contact action.
Okay, so that's going to be dismissed. Exam. And that's a warrant for Sidney Garrett's son.
Yes, Judge.
That's gonna be recall.
I'll hand this to your staff, Judge.
Oh, you could just bring it right up here. Thank you, thank you. Okay, I think I've signed off on everything to dismiss the state case. And here's going to be the order, which the clerk will distribute, recalling that material witness warrant. And if you want to wait for your copy, then you're all set. And what are we doing on the city case?
Your Honor, we've agreed, she will plead guilty to, or no contest to no massage license at the time,
Okay, so that's as charged.
as charged. And then we're just requesting, a fine reassessment.
How much are you looking for?
$250.
Okay, Miss Han, so you understand you're going to waive your right to have a trial, which you have a right to have a trial with your lawyer representing you on the no massage establishment license charge. You're going to be waiving that and you're going to be pleading guilty or no contest, meaning that I'm going to look at a police report to see if there's enough information there to convict you of this charge. And if there is, you'll just be convicted of not having a massage license. And if there isn't, of course, then you won't be convicted of it. But I will be looking at that to determine if there is sufficient evidence in, and you likely could be convicted. People are not requesting any jail time or probation on this matter, but there might be some fines and costs assessed. So is that what you want to do? Okay, let's go over all of the constitutional rights that you do have that you're getting ready to give up because you're entering into this no contest plea. Now, if you understand these rights that you do have that you're getting ready to waive, then all you need to do is say yes as you go over these rights together with me. All right, so of course you have a right to have a trial by judge or by jury with your counsel representing you. And you understand you're going to waive that. And you also have the right at that trial to subpoena witnesses. That means you have the right to ask the court to order witnesses to come forth to testify for you. You understand that you're going to waive that. You have the right to question through your lawyer any witness brought against you by the prosecution. You understand you're waiving that. You have a right to testify at a trial on your own behalf. But if you choose not to testify, no one can hold it against you. And you understand that you're waiving that. Also have the right to be presumed innocent of any charges here unless you're proven guilty beyond a reasonable doubt by the prosecution. You understand you're waiving that. Now, if you're on probation or parole status now and you plead today, no contest, then the no contest plea still could be a violation of probation or parole status because it could be considered a new case. You're not supposed to get a new case while you're on probation or parole status. So it could be a violation. You understand that? And you have read and signed the advice of rights form, gone over that with your lawyer. Any questions about anything on that form? Understand if I accept the plea, you will not have a trial. You'll be giving up the rights on the form. You also understand the possible penalties involved here with a no massage establishment license. You still wish to plead no contest to that charge. Anybody force or threaten you to make you give up your right to trial?
No.
You've been promised anything other than what? Actually, nothing. And are you pleading freely and voluntarily after speaking to your lawyer? And you understand that if you wanted to appeal something under number 11 on your form, it talks about you'd have to appeal within 21 days. You'd have to have a right to appeal or request permission to appeal. So you have to appeal within 21 days of sentencing, and you'd have to request a lawyer for an appeal if you wanted one appointed within 14 days of sentencing. So you understand that. Okay. So did this offense occur, let's see, on or about the date of February 19th, 2025 at 17670 West 12 Mile Road, City of Southfield? And were you at that location operating, conducting, or carrying out?
Your Honor, this is a no.
Oh, that's right. I'm looking at the police report. And that would be 250005831. Southfield incident report number. It's dated February 19th of 2025. And let's see, the address is still the same. 17670 West 12 Mile Road, City of Southfield.
It's a rather long report, because I have to deal with.
I know.
Okay,
I'm,
I can direct you to a particular page.
what page you want to tell me about?
You're looking at page 12 through 13, I believe,
Mhm.
talk about the license issue.
Under the bold, there's the please note. Yeah, it's the top line.
13.
Okay, well. Well, it looks like on page 12 of the report, there's some information here. The Southfield police officer said that the incident occurred on the February 19th, but on February 20th, they made contact with a Chuck Woodward from the City of Southfield Building Department. And after advising him of the incident, Mr. Woodward told them that they had no record of pressure point, which I'm assuming is a massage, because you made me skip the point where it talked about what kind of business was being operated here. But Pressure Point was at that location, no record of that, and no record of them applying for a license, and that the building would be posted by February 21st, 2025, and the owner would have 10 days to become compliant. And if I look back, this was all related to an investigation of some person getting a massage at the location. So back massages and other things. So this did appear to be a massage establishment at the time, and per Mr. Chuck Woodward, no license. Is that sufficient factual basis?
Your Honor, and then on page 8, further investigation, and you look at what it says.
Y'all told me to go to 12.
I know, but I mean, then this will establish they choose the owner.
Okay, let's see.
If you look.
Pressure Point Garrettson, okay.
Where it starts, where it says in 2022, Sydney was listed as one of the main females that was involved in the illegal activity. The massage parlor is located at 26321 West Tarbell Road. The owner was listed as Rhonda Hahn.
That's on page 8.
Mine might be different. Which one I'm talking about?
Well, I got on page 9, Han confirmed that she is the owner of Pressure Point.
Yep, that's.
According to Han, she's been in the massage business for approximately 25 years.
I just wanted to establish that she was the owner.
Yes.
So Your Honor, we stipulate the facts.
Okay. All right. So you agree that's sufficient factual basis? All right, then the court believes that is also sufficient factual basis for the plea. Court rules were complied with, and that this plea is freely, understandably, voluntarily, accurately, and knowingly made. And so we'll accept the plea. No contest plea is charged. Would you need to say anything on her behalf?
She was in business for 25 years, generally was registered with the city and held a license
What happened? Why didn't she stop getting a license?
financially.
How much is the license?
100.
Oh, she had made $100.
I mean, I'll tell you once she's ever come back for this court or any other regarding any of these issues, I think it was a very valuable lesson.
She shutting down massage business.
Yes.
Yeah.
And that one's destroyed, that, where the center, where this was. Yeah, the building's no longer even there.
Okay, well, that was fast.
And Your Honor, she wouldn't.
I mean, it was just
If she tried
February.
to open up something in Southfield, she wouldn't qualify for a business license in Southfield.
But
Going forward.
just to add, Judge, I would just ask that the court impose the fine the parties agreed on, $250 to be paid today. There was a bond of the original.
I got a $75 crime victims' rights fee I have to say.
Some,
She has a $500 bond. I can take it out of that. It's in her name.
maybe one on the state, but I was gonna ask that be returned.
Yeah, I canceled it, so it can go back to her.
But I think the outcome's appropriate.
Okay, Ms. Hahn, anything you want to say? Okay. All right. Well, you got a real good break on the state case. So, just, well, thank you. But I hope you mean in this context. But yeah, just have learned something from it and just move forward with your life and do good things. All right. So $250 fine, $75 crime victims' rights fee. I'll take it out of the $500 fine and I can refund the balance.
Thank you.
What is the other fine? Yeah.
Thank you.
Just put a refund.
Courtroom versus Anthony Little and the Imperials. Property at 307 West Chicago Road, Suite 250 in Sturgis. What building is this, Miss Wortman?
That's where Elwood Staffing is at. It's the former Manpower used to be there. And then
So is
Sturgis-
this a private residence or is this a commercial lease?
No, he broke his foot and he was doing paperwork for Elwood Staffing so that he could get workers' comp, get paid weekly.
Well, was he
He was
living in the
employed.
Elwood? Was he living in the, he's living in the Elwood Staffing office suite?
No, that was the only way I knew how to get a hold of him.
Well, where does he live?
He never mentioned to me, I know he was staying at someone's house 40 minutes from Sturgis. And I didn't bother asking him and then I blocked him. I
Well,
blocked his phone
through
calls.
this, you're asking to evict him from 307 West Chicago Road, Suite.
No, I'm asking to evict him from 23296 US 12 West.
That's not what you filed.
Well, the clerk out here had me fill out the paperwork. Well, she helped me.
All right, well, here you go. Address or description of premises, 23296 US 12 Sturgis. Okay. And you own those premises?
Yes,
All right. So this is your same house?
yes.
All right, boy, this isn't clear here. She did a judgment, but it's got the wrong address on it. Let me see what kind of service we have. I don't think, he was personally served. All right, he's subject to being evicted. He's not here. Where is he?
That I couldn't tell you.
Does he have property there?
Yes. 4 motorcycles, a Jeep. He only took his summer clothes with him. So he's got all of his winter clothes, a bunch of coats. He's got his mom passed away 2 years ago. So we got
Now,
all
who is he to you?
nothing.
Is he not related to you?
No, he's not related to me.
All right, how long did he live there?
A year. But I'd asked him to move out before that. But I couldn't get him to move, so that's why I brought it to court.
All right, well, he isn't here, so he's subject to default. He has 10 days to vacate, or you can come to the court and ask that he be evicted and his property be put out in the street. I'll have the clerk change the address on here. It's not 307 West Chicago Road.
No, that's where he actually got served at.
All right, well, that's not where he's being evicted from. He's
No.
being evicted US 12. 10 days from today is September 25th. So he just up and left all of his stuff there?
Well, he tried to make contact with me, but like I said, I didn't want to talk to him. Cause he was wanting to move back in and I didn't want to hear it.
Well, you have to have communication from him. He has a right to come get his property out of there.
Well, the last communication I had with him was, right before the US 12 sale, because I told him he could come and sell his stuff if he wanted to. And he said, no, he didn't want to sell his stuff, he wanted to keep everything. So I told him, I said, well, you're gonna have to find some place to put it. And he said he didn't have nowhere to put it.
All right, well, this is messy. If he doesn't vacate, he's subject to being evicted, which is when the sheriff comes and always puts his stuff out of there. But you can't hide from him. If he tries to contact you, you need to talk to him. Allow him to come get his property.
All right, I'll unblock him and I'll let him know he has to come get his stuff.
Yes. But he knew about this hearing because he was personally served with it.
Yeah, actually twice. Because the process server served him and then he called me while I was at the post office sending more paperwork to the 307 Chicago.
All right. Well, I'm not exactly sure what we got here. No lease, you're living in the same house. He's got what could potentially be valuable property plus personal property. But yeah, he's got to have a right to get it out of there. And trust me, it's a lot easier for having him come get it than have the sheriff park it on the curb. That's not a good way to deal with it.
Okay, and also, I want to be compensated financially for the money that I gave him, because the truck he's driving, I paid for.
All right, that's a small claims matter, not part of a landlord-tenant matter.
Okay.
If you're suing him for rent, you could be part of this.
There's no rent. I didn't charge
then,
him rent.
yeah, if you lend him money or you gave him stuff and you want to be compensated for it, you have to file that in the small claims court rather than the landlord-tenant court.
But what if it's close to 20,000? That is small.
Well, you can
claims.
sue, no, small claims is up to $7,000. If
So
it's up to
get
23,000, you can file in general civil court. But then you're gonna have a tiger by the tail because you have to file proper pleadings in a general civil case. Small claims is much more relaxed. Plus, it's not, well, I don't know, maybe you'll get $23,000 out of them, but you could sue for up to $25,000 in district court and up to $100 million in circuit court. But you can sue for $7,000 without a lawyer in small claims court. Anyway, if you go out to the counter, the clerk will give you a copy of this order saying that he has 10 days to move or he's subject to being evicted.
Okay.
All right, good luck.
All right, thank you. What do I?
Just a minute. Motorola just showed up. What's your name, sir? What's your name, sir? Motorola G Play 2024.
My name is Anthony Lee Little.
Well, Mr. Little, you're late for your own party.
It's supposed to be,
We just spent 10 minutes
supposed to
talking
be
about
1:35, but I tried to check in around 12 o'clock.
Let's see, it was set for 1:25. All right, let's bring Miss
Sorry,
Wortman back.
I guess I did miss it, but I was trying to be in there just after 12.
Well, you missed it. Elaine, would you send Miss Wortman back in? Mr. Gann, I'm sorry, we got sideways. This last defendant was late for his hearing. I thought we were done.
No problem, Your Honor, please.
Are you still there, Your Honor?
I'm still here, but you've messed up my afternoon. We've got a number of other people that are gonna have to wait around for.
I apologize, but I'm just trying to retain my property.
All right, well, what I ruled is the pleadings were unclear, but she's evicting you from her house at 23296 US 12. Now that you're here, I've got to advise you of your rights as a tenant in a landlord-tenant proceeding. Mr. Ashbrook, can you hear me?
Mr. Little, Anthony Little.
Yeah, there's another guy here named Sheldon Ashbrook. And
Yes, I
make
can
sure.
hear you, Your Honor.
All right, I'm going to advise you both of your rights as a tenant in a landlord-tenant proceeding. You have the right to hire an attorney. If you cannot pay for one, you may see if you can get assistance from legal aid or other legal services. We do not have court-appointed attorneys in civil cases. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first court appearance, make the demand in writing within 5 days of today's hearing and pay the $50 jury demand fee unless the judge waives your obligation to pay the fee due to inability to pay it. If your landlord has asked you to be evicted for non-payment of rent, this would apply to Mr. Ashbrook, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or if you're a veteran, you may possibly get veterans assistance. You do not need a judgment against you to get help from these places. A copy of the summons and complaint from your case are sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, we can set that up. And it also could result in what's known as a conditional dismissal. If the parties are able to reach a resolution, we can assist in preparation of that. Whoops, give me a second. All right, what Miss Wortman says, Mr. Little, is you've been living there for about a year with no lease and no rent, and she wants you to move. She says you've got a number of items there, including a Jeep and some motorcycles and some other things. And she wants you to move your property.
Well, my health condition, when I was forced out of there on 7/7, I was supposed to be in surgery on 7/8, and I have a severely broken foot, and I can't put no pressure on her or nothing. And I have all my stuff is documented, and she sent all my mail away. Well, I still had the address, and cost me 2 insurance policies. I got knocked out on my Medicaid and my truck insurance, and she sent my truck title back and 2 payroll checks, and she's done everything she could do to stall for time. And my whole entire property and my life is there. And also my mom died just before her dad did. And everything that I own and stuff is there.
Your truck insurance was in my name.
Miss Wortman,
My
I didn't ask you. Miss
policy.
Wortman,
Yeah.
I didn't ask you anything. We're not sitting around the kitchen table. We're in a court hearing. And what he's alleging is he violated the Landlord-Tenant Relationship Act, the anti-lockout law. How did you come to live there, Mr. Little?
Well, her and I lived as husband and wife. We met each other at work, and that's what we were living as husband and wife. And she never even served me the original papers.
All right, that's all right. She just said there was no relationship. Okay, so, you're not a tenant, you're what's called a tenant at sufferance. You don't have a lease, you're not paying any rent, she owns the house and she wants you to move. She
Well, I
served
did.
it on.
I
Yes, now
let
you
the
said she forced you out on July
seven,
7th. How was
seven,
that?
seven, and it's all on video. Her daughter and her daughter's husband, and I haven't even had any protection. I have a registered firearm there, and she won't even give me any of my stuff. She won't even give me my clothes or nothing. And she's been stalling for time this whole time because she just wants to take all my stuff. So I don't
All
even
right.
have any.
So,
I don't even
all
have
right.
any pants. I don't even have no clothes to wear to be presentable in court today, Your Honor.
All right, well, you're here by Zoom, even if you were late. So what do you mean she forced you out?
Well, that's what happened. Her daughter and her husband pulled in behind me in the Jeep. She was supposed to take me to the hospital, and it's all on documentation with the doctors and stuff. And I missed my surgery, and I almost didn't even get my surgery. I had 2 days to find somebody to help me because you have to have someone to drive you
All
there
right,
and stay.
so what, they just said, leave and don't come back?
Yeah, and they gave me a little bit of clothes in a basket, and it wasn't even my clothes. And I've been living with no clothes and living in my truck and everything with a broken foot, and I didn't even have cast on it. And her daughter's husband wouldn't even let me out of my truck
All
and
right, well,
said,
stop. They can't do that.
"Well, they did it."
Well, all right, all right.
And,
Now I'm
and
gonna
she
try to
didn't.
get
She
to,
didn't even serve me the papers.
all right,
And
stop. You're here now. She's here now. She didn't follow the law. You can't just throw somebody out like that. She says there was no relationship at all. Apparently you were in some sort of relationship. She blocked you from email or other messages so you couldn't communicate with her.
everything.
She did will you stop interrupting me, sir? This is a court hearing. If you
I
were here, maybe
apologize.
it would be
I
more,
I didn't want to do it on the
stop.
phone, Your Honor.
All right, stop. What she did was called an unlawful eviction. You can't just throw somebody out like that when they have a tenancy. However, you got to get your stuff out of there. I told her that she needs to allow you to remove your property. She has to give you access. You were a tenant. You weren't a trespasser. You were living there as part of a relationship. The relationship ended. She wanted you out and threw you out. But she's got all your stuff. You need to get your stuff and get it out of there so you can end this relationship. Miss Workman, you're not gonna like this much, but he's entitled to a 7-day adjournment before I execute the date for the removal of the property. Mr. Little, how soon can you get your stuff out of there?
Well, see, I've been at a disadvantage this whole time because my foot is severely broken and it has 15 broken bones in it and more stuff than that. I have a big list, and I
All
was
right,
supposed to
never
sleep
mind.
in my truck, and I could have had a
All right.
blood clot.
She also wants to sue you for $23,000, but that's a separate issue from this. We need to keep this case moving, even though it hasn't been done right. And at some point, we need to get this resolved. Today's the 15th.
Yes, sir.
So I'm going to continue this matter for 1 week.
Well, I
Stop.
would like to come in the courtroom and see you, Your Honor.
Well, you have a chance to next Monday at 2:15.
Okay, I'll be there in person.
All right, now
I-
let me tell you what happens next. That's 9/22/25 at 2:15. You would get 10 days from that day to get your stuff out of there, or she could seek an eviction where the sheriff comes and puts all your stuff out of there. So Miss Wortman, you need to let him come get his clothes, his motorcycles, his property. So the law says that the defendant is entitled to at least one 7-day adjournment. He's not in the position to immediately get his stuff out of there. So I'm going to adjourn it for a week, but I'm going to tell you next week, you have 10 days from the 22nd of September to get your stuff out, or she can have the sheriff haul it out.
The
I
22nd
told,
of September?
yes, that's our next hearing, next Monday at 2:15.
Thank you.
So Ms. Wortman will address the matter further. You need to allow him to contact you, make arrangements to get his stuff out of there, and see if we can. Mr. Little, do you have any people anywhere?
All my family died, and she was like the only friend I have. So.
All right. Well, I wish I had a better answer for you. But at some point, you need to get your stuff out of there.
Well, I've been trying.
All right, I told her she needs to let you do it. All right, we'll do it in court next week, September 22nd at 2:15. You're both free to go.
Well, thank you, Your Honor. And I'm sorry I was late.
Yeah, be here on time next time. You kind of got us a little sideways here.
Well,
Thank you.
I apologize, but
Okay,
What about his mail?
you hold on to his mail. We'll talk about that next week when everybody's here.
Okay.
I do have the complainant for the underlying offense as well as Ms. Lopez here. She may come up in the court. I need to admonish both of these individuals per my conversation with Ms. Lopez.
Okay.
If you've gotten to the point where you're frustrated, Ms. Lopez, you know there's an issue.
So are we going to go through the motion? Are we,
Yes, please, Your Honor.
so let's do that first. Good morning, Ms. Lopez.
Good morning.
And sir, you're Brandon Bell? The best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay. And will he waive the formal reading of the motion?
So
Give me just a second to get that pulled up. Mr. Bell, in cause number 24, DCCR 1008, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to immediately report to the community supervision officer your contact information. And is that true or not true?
I failed to. True or not?
It's just true or not true. You can explain later. So did you give them your contact information or not?
Yes, ma'am.
You did give it to them?
Yes, ma'am.
Okay, so that's not true. Count 2 alleges that you provided a urine sample May 29th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 3 alleges that you provided a urine sample July 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you were at a location other than your residence at approximately 3:10 a.m. and 4:55 a.m. on July 10th of 2025 in violation of probation. Is that true or not true?
True.
Count 5 alleges that you failed to provide all records and documents required by the supervision officer within 30 days of their instruction. Is that true or not true?
Not true.
Count 6 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Have you done the BIP program?
No, ma'am.
Okay. So that would be true that you haven't successfully completed it, right?
Yes, ma'am.
Okay. Count 7 alleges that you failed to that
I
you
think
fe-
I should say not in there, Judge, I'm sorry. Didn't- He felt to not have any communication.
state wish to amend that to say not on number 7.
Yes, Judge.
Fail to not, any objection? So 7, hold on, let me make that. I'm printing it because it'll be easier for me. All right, so 7 says that you failed to not have all communication with the victim regarding your child through an approved third party by repeatedly appearing at the victim's house to, quote, see your children. Is that true or not true?
True.
Count 8 alleges that you admitted to the adulteration of your urine analysis on June 30th of 2025, and is that true or not true?
True.
You understand adulteration means? And the court could explain adult, I don't think he.
I mean, did you show up to probation and do either a fake urine sample or have some type of, what was it,
He admitted to drinking something that made his urine negative.
gotcha. So did you do that?
No.
You didn't? You just admitted it, but you didn't really do it?
Did you say it, or did you say that or not? That you admitted to drinking
So
something?
it says you admitted to the adulteration of your urine analysis, that which means you told your probation officer that you did something to make your urine analysis negative. Is that true or not true?
Well, any piss test,
Urine test.
Listen.
Urine test I failed with.
Listen to my question. I don't care about any of that.
Yes, ma'am.
Did you admit to your probation officer
Not that I
that
know
you,
of.
did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Okay.
Let's say not true.
Count 10, let's see, actually count 9. Hold on, I'm out of 5, 6, 7, 8. What I missed here? Count 9, so this goes over here, alleges that you had contact with the victim of the offense, either in person, by telephone, via mail, or through a third party several times after being put on probation in violation of your order. Is that true or not true?
Can you say it again?
Have you had contact with the victim of the offense?
True.
And then count 10 alleges you are behind in your court-assessed fees as of July 17th, 2025, in the amount of $337. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, 4, 6, 7, 9, and 10 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So we've got, I'm going to find those counts true. Ms. Lopez is here. Let me look back at something real quick. When was the last drug test?
My last drug tested him on the 18th of August.
And it was negative?
It was negative.
And has there been any follow-up or treatment with spinal top?
You mean mental health or
Mhm.
drug treatment? Mental health, yes.
Okay.
Yes. Weaver? Oh, wait, Your Honor, I apologize. August 18th was his last drug test, and he tested positive for THC. He has since been drug tested again in September, and it was negative. I gave you the wrong date there. I apologize.
And I think the concern, if Ms. Lopez can kind of go into a little bit more detail about our conversation, is that he may be using synthetic, which doesn't show on the tests at probation. And there's obviously an issue with the no contact, which is why I have the complainant here. I don't think either one of them are adhering to that.
So last known contact that you know of that's not in here, has there been any?
I was called by the complainant on Thursday of last week, and she admitted that they had been seeing each other that day. And she was angry, but it's very inconsistent whether she wants to be around him or not. Some days I get calls.
Well, but I told you
If it come back in front of you, just be quiet.
I told you you can't have contact,
Yes, ma'am.
and you're the one that can go to jail.
Yes, ma'am.
Okay, based on all of these allegations, I realized that I reinstated a bond and we had a hearing, it looks like, where I ordered some spindle top, but it sounds like this is not going in a safe direction at this point for anyone. At this point, I'm going to find that it is in the best interest of our community, best interest of the victim, and based on all of the factors, in 15.17 and the fact that you're on probation for an aggravated assault with a deadly weapon, I am going to make this, at this point, a no bond. You will go back with the bailiff. I'll reset your case for an updated pre-sentence report. We can have any other testimony at that time with regard to the other allegations that are still pending. If you have any witnesses, then...
Since she's here, do you want to elicit testimony from the victim or not? She is
Judge,
here.
what my preference would be, may she come up to be addressed by the court?
Yeah.
Ms. Bell? The nature of this plea originally, Judge, was obviously a little bit low. It was based on some cooperation, non-cooperation, cooperation, non-cooperation, which I believe is still the case. I don't know what.
Look this way.
What is, I don't
You
know the
look this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through Ms. Lopez that they're continually together, in that, in addition to Mr. Bell, she is also violating that no contact order by voluntarily engaging.
I think they got children together as well, is that right?
Well, that's why.
You're pregnant now, is that right?
But that's why I made the specific rule that they go through a third party to transfer kids, to see
And
kids.
the problem is that the third party is his mother, which is, I've told him multiple times, cannot be.
Cannot be. Okay.
It's not working.
You are pregnant with this child right now?
Yes, sir.
So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? Whenever I did call the probation officer, technically he was already staying at the house. We both our names are on the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because, me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go. And obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there, and that's why you called?
Yes, ma'am.
Okay,
Then
it's
staying there.
all right. Well, then you know what you have to do. You're the one
I
on.
got out the house and I waited on my ride before my ride came.
Well, if you're staying at the house and you're, I'm resetting it for a sentencing hearing. If there's any testimony at that time, you can recall witnesses, and so we'll come back.
I would implore the court to admonish them that contact includes calls from the jail.
It does. Contact, communication. Contact doesn't just mean in person. All right? It means communication. So you can't call her from the jail. You can't talk to her, period.
Man, we have children together. We have 4 kids together. I'm going to have another child for him. How are we supposed to, how are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for a felony assault of you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Man, I'm trying to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's the choice that you're making to still be with somebody that assaulted you. You can go back, go. You can go with the bailiff.
get an updated PSI?
Yeah. I wrote on the front page, but I also wrote on that other page where it was the update. Yes, ma'am, thank you. Mr. Burbank, you have Brian Mitchell.
Yes, Your Honor.
Good morning.
Management, like Chase Carlson and Amanda Williams, 24-07290. Council, can I have your appearance?
Good morning, Your Honor. Jessica Larson appearing on behalf of the plaintiff.
Is this Amanda Williams?
It is.
Okay, and Mr. Carson, you can remove your hat. This is the court proceeding. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I'll do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in the landlord-tenant?
I requested, yes.
You made was there a demand on
In
this?
written, I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. I did not have the money at the time, nor would I have it.
But sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
No,
don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom and you will not talk over people. You will present the evidence. I'm absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm gonna make it clear on my record that I don't make, and I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let
I run the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer. And
I have evictions every single week, and the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding. Because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you and the plaintiff has the right to figure out how they can recover on that judgment.
Can we
Do
speak?
you understand that? Yes, you may.
Well, we tried to tell her, like, the funds, we can pay them. Like, we have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor. I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtor's exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
Okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. I'd like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I have seen since I walked out of your courtroom, attempted to file for an appeal, and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially, but I've received, like, the judgment is for, you gave them and rewarded them things they shouldn't have had. We weren't there.
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand. So if you didn't get a trial, that was on you.
Then I guess I misunderstood, and that goes back to me not being a lawyer and wishing that I had.
That does not go back to you being a lawyer. We made a video. We make a virtual presentation. It's a video that I play, and every courtroom in this court plays that video at the first appearance. Most of you all don't pay attention to the video. It tells you very clearly in very plain language, you have the right to a jury trial. And you can make such demand for a jury trial, and it tells you how to do that. You don't need to be an attorney to do that.
Sorry, go ahead.
I'm done.
Can she produce an actual number, or are we going off of what she thinks?
So I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
You can do one of two things, sir, because I'm not gonna, the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. Or I can reset this and order you to appear in person. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter. So it's in your best interest to comply. It sounds like she's willing to work with an installment payment order, but only after she gets the answers that she needs to figure out how they're going to recover on this debt. So
And I
how
did
do you
ask him
want
if
to
he
proceed?
had, I'm sorry, Your
I'm
Honor.
sorry.
I asked him if he had any of the documents that there were, in addition to information, there's documents, plenty of documents that were asked for, and he indicated that he wasn't going to produce those. So I would ask him to appear in person with all of the documents.
Oh.
And I'd also ask that, Your Honor, that he return to a tone that is respectful. He has screamed expletives at me the last time we were here in court, and he's called me things today. And it's uncalled for and unnecessary.
I am absolutely clear that the emotional charging was not from the courtroom. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process. You can appear in person. I'm going to reset this date, and you need to bring the documents that were ordered under the subpoena. If you fail to comply, the court will issue a bench warrant.
Your Honor, save yourself the time. Have her facts.
Don't tell me what to do.
I'm
And
not.
don't tell me what to say.
Or
You instruct yourself.
I'll pay her
You
in
instruct
full.
yourself. You instruct yourself, or you'll be in contempt of court. Okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I've already given you an opportunity.
Your
I'm
Honor.
now resetting this. I'm now resetting this. You can appear in person. If you pay in full, then they can move forward to make sure that this removes off of my docket. But do not tell me what to do. I do not tolerate your tone. This is how we got here the last time. That might work with the lady. That might work with the lady sitting next to you, but you don't talk to me like that. Not in the court, not outside the court. Do you understand that?
I'll pay the balance.
Thank you.
My phone number is on all of the court paperwork. You can give me a call and I'll give you a number.
Give me a new date.